Hello, welcome back for our last segment for chapter 6. So in this section, we're going to talk about interrogation. So it's the last part of chapter 6, the last police procedure. So the first one was an overview of concepts and stuff for procedure. And then we talked about specifically search and seizure, stop, question, frisk, arrest. This one's specifically going to talk about interrogations. Okay, so we are now going to focus on what are the procedures police have to follow when you're talking about interrogations. So the first thing we have to do, just like we did with the other things, we have to define the term. So we need to know exactly what we're talking about when we say interrogation. What qualifies as an interrogation? And the law says basically an interrogation is any questioning by police in order to obtain incriminating evidence or a confession from a suspect. So that's what we're talking about when we say an interrogation, okay? Now, what constitutional amendments govern police interrogation? So we said search, seizure, stop, question, frisk, arrest are all governed by the Fourth Amendment. But did the Fourth Amendment say anything about interrogations? And the answer is no. So when we're talking about interrogations, we're actually talking about different constitutional amendments. We're talking about the Fifth and Sixth Amendments. So specifically, we're talking about the Fifth Amendment right against self-incrimination and the Sixth Amendment right to an attorney. So these are the two provisions in the Constitution that are specifically going to govern what police can do with police interrogations. Okay, so one of the first things you always have to look at when you're looking at a police interrogation is that the interrogation itself has to be voluntary. So police cannot beat or force somebody to confess. If they do, that is a blatant violation of the Fifth Amendment due process clause. So all confessions must be voluntary. So when you're assessing an interrogation, you always have to make sure that the witness is there voluntarily. So if you look at this, is this a voluntary confession? And how do we know? Well, it's not. You're being forced, you're being coerced into confessing. That would be a bad confession and it would be excluded under the exclusionary rule. Now, the Sixth Amendment specifically provides for the right to counsel. So then we have to decide, when does that right kick in? So we know we have the right to counsel when it comes to trial. You have the right to an attorney at the trial. But the question is, does that right kick in during a police interrogation when you're actually arrested and you're being interrogated? Do you have the right to counsel? And the Supreme Court has said yes. And this is a landmark case, Escobedo versus Illinois. And what happened is Escobedo was accused of killing somebody. They brought him in, questioned him. He didn't tell them anything, so they let him go. And then a while later, they go and arrest him again. And this time his family calls his lawyer, and his lawyer shows up at the police station and says, I want to see my client. And the lawyer is refused. The police will not allow the lawyer in. And at the time, they're just badgering Escobedo, and he finally confesses. And the court said, no, that is not right. If you have an attorney, you have that right of the attorney to be there during that questioning, and you have the right to see your attorney. So this is very explicit right in our Constitution. If somebody requests attorneys, all the questioning has to be stopped until that attorney is present. Okay, so that's one important rule for interrogations. But we said it's two constitutional amendments. We said it's the Sixth Amendment right to counsel, but we said it's also the Fifth Amendment. The Fifth Amendment specifically says you shall not be compelled in any criminal case to be a witness against himself. That means you cannot force somebody to incriminate themselves in court or even during an interrogation. So you have the right to remain silent. You don't have to answer questions. Those are considered two separate and distinct rights: the right to counsel, the right to against self-incrimination. There's two separate and indivisible rights or divisible rights that can be asserted when you're talking about interrogation. So this Fifth Amendment has become known as the right to remain silent. So what happened then was there was a case of Miranda versus Arizona. And in Miranda, there was a man, he was suffering from mental difficulties. He said he had sexual fantasies of raping girls and things like that. And they believed he kidnapped and raped a little girl. And so they were questioning him for long periods of time. They told him they were going to get him help. They made him all these assurances. And then he finally agreed and he finally confessed to the crime. And his lawyer said, wait, that was not fair. You have the right to counsel. You didn't give him counsel. He has the right to remain silent. You didn't even tell him that. And he already had mental difficulties. That is wrong. And the Supreme Court agreed. The Supreme Court said, you are right. You have these two rights, Sixth Amendment right to counsel, Fifth Amendment right against self-incrimination. We are going to require that the police tell you these rights. So what they did, though, is they said the police are only required to tell you these rights if two things are occurring. Number one, you are in custody. You're actually under arrest in some way, or you're in custody. And two, you're actually being questioned. So you don't have to read Mirandas unless both of those things exist. The person is in custody and is being questioned. So you're not in custody, they can ask you whatever you want. You are in custody, but they don't ask you any questions. That is fine. So it came up with this Miranda warning. And what the Miranda warning says is it specifically tells suspects their rights. You have the right to remain silent. You have the right to an attorney. It was a pretty crazy case at the time because nowhere ever did the Supreme Court ever say that your rights had to be told to you by a police officer. So people were very, very unhappy with this, and they thought it was an overreach by the Supreme Court because it didn't ever say anything. They don't say you have the right to free speech. You have the right to carry a gun. Nobody's ever going to tell you those rights. So it was quite a big deal when the Supreme Court said, no, if you're in custody and being interrogated, they must tell you your right to remain silent and your right to an attorney. So if you want to see all of your Miranda rights, these are them. For a while, there was a big push that they had to be said exactly. If there was any discrepancies in them, then it would be bad. It could be a bad interrogation. They've relaxed that a little. As long as the main focus of what they're trying to convey is conveyed, then it's okay. But you can see the different rights. You have the right to remain silent. That's your Fifth Amendment. Anything you say can and will be used against you in a court of law. You have the right to an attorney, Sixth Amendment. If you cannot afford one will be appointed. And then we always ask, do you understand these rights? That becomes a very, very important question when you're talking about Miranda, because unless the person actually understands what's being told to them, they can't decide whether to assert their right or not. Okay, so just keep in mind that Mirandas only have to be read when you have what's called a custodial interrogation, which means number one, the person is in custody, and number two, the person is being interrogated. If both of those factors don't exist, then it is not considered necessary to read Miranda. So one more thing I was going to tell you about this. Custody is usually based on the idea of arrest. So remember, we said the test for custody, would a reasonable person feel free to leave? So first you'll determine, are they in custody? Would a reasonable person feel free to leave? And then interrogation is going to be some form of questioning. Now, remember, we said it can also be suggesting things to force the person to say. So the police with the man in the back with the little girl, and they're saying, sure, would like to give her a Christian burial. That also can qualify as an interrogation. Okay, if you have both of these, you better read Miranda. Now, what are the consequences? What if I interrogate somebody prior to reading Miranda? Well, anything that I obtain, the confession itself is going to be excluded under the exclusionary rule, and any evidence I obtain based on that confession. So yes, I killed her, I buried the body. So the confession itself will be excluded. And then the body and any evidence on the body is fruit of a poisonous bad interrogation. So that is also going to be excluded. So there's very, very harsh consequences for violating Miranda. Now, once a person is read Miranda, it is that person's choice whether they want to assert their rights or not. So the police will read Miranda, and then the person has to decide, do they want to remain silent? Do they want an attorney? They don't have to use their rights if they don't want to. If they just want to talk to the police, they can just go ahead and talk to the police. They don't actually have to use their rights. If they don't want to use their rights, then they have what's called a waiver. So they can waive their right. So they can waive their right to remain silent and keep talking. They can waive their right to counsel and not have an attorney present. Sorry. My voice is funny. So if they are read their Mirandas and they want to waive their right to speech, to talk to the police. So you have the right to remain silent. You say, no, I want to talk to the police. You can do that anytime you want. So if you start to talk and change your mind, you can change your mind and say, no, I don't want to talk anymore. Okay. Or if you assert your right, I don't want to talk, you can change your mind and later say, okay, now I do want to talk. So you can make up your mind anytime during the interrogation whether to assert or waive your rights. If you assert your right to remain silent, they should really stop questioning you. They shouldn't keep asking you questions. Now, the right to counsel is a little different. You can waive it if you want. So if they read it to you and you don't want an attorney, you can just say, no, I don't want an attorney. But if you assert it, if you say, yes, I want an attorney, you cannot change your mind. The only way you can change your mind is if the attorney shows up and is sitting right next to you, and the attorney then says, nope, he changed his mind, she changed her mind, she does not want an attorney. So right to remain silent, you can assert or waive, I want to talk, I don't want to talk, I want to talk, I don't want to talk. You can change your mind as many times as you want. But once you assert your right to counsel, I want an attorney, you cannot change your mind. You are required to have an attorney there for any more questioning. And the only way you can change your mind is if the attorney says the client changes their mind. If you ever have an attorney that says that, immediately fire them, because any attorney that knows anything would never allow a client to ever talk to the police without their presence. But you can only do that if your attorney is actually present. So I created a little assessment. It's called the Miranda Practice Assessment. Again, it's just a way to review the material. It's not required, but it is posted in Blackboard if you wanted to see it. So just to put it all together, a Bank of Batavia is robbed. Betty, bank robber, is the suspect. They approach Betsy and ask if she will answer questions. She agrees. The police escort her to the police station. They put her in a room and begin to ask her questions about her whereabouts at the time of the robbery. At first, Betsy answers the questions, but then she asserts her right to remain silent. Once she asserts her right to remain silent, they make her wait for an hour just sitting in that room. After an hour, she tells them that she'd like to answer questions again. After a few more questions, she says, well, I think I want an attorney. The police tell her that it is a really bad idea to have an attorney because it will make her sentence harsher. She agrees and fully confesses to the crime. After her arrest, she contacts you as her defense attorney. So now, based on everything I told you, we have to decide, is this a good interrogation, or will the evidence or the facts she says during her confession be excluded under the exclusionary rule? So remember, Miranda only kicks in if you have custody and an interrogation. So the first question you have to ask, was Betsy in custody? Remember, for custody, we use the standard of an arrest. So would a reasonable person feel free to leave under the circumstances? So when they take her to the police station and lock her in a room, would that mean a reasonable person would feel free to leave? So I would argue she's in custody. If you're locked in a police station room, you probably do not feel free to leave. So the next part is Miranda, did they interrogate her? Did they ask her questions? And yes, they did. So she was in custody, she was interrogated. So they should have read her Miranda prior to asking her the first question. If they didn't, everything from that point on is bad and it will all be excluded. Now, let's say they did read them to her. They read her Mirandas. And at first she says, I waive my right to remain silent. And she keeps talking. And then she changes her mind and then she changes it back. Is that okay? Is that a valid waiver? Can they use what she said during those times she spoke? And the answer is yes. Remember, you can assert or waive your right to remain silent anytime. But then later she changes and says, I want an attorney. After that, all questioning should have stopped and they should have gotten her an attorney. Now she changes her mind later and says, no, that's all right. Can she do that? No, because she already asserted her right to counsel. And the only way to do that would be to have her counsel sitting there next to her, waiving that right. Okay, so that's kind of the analysis that you have to go through when you're thinking about these particular cases. So the last issue I just want to talk about real quick is there's a lot of pressure on police now to start recording confessions. One of the things that people ask is, could a police officer ever force or get a person to make a false confession? And a lot of people say, no, there's no way I would ever admit to something I didn't do. I would never confess. There's no way. But there's been a lot of psychological research, and they have proven over and over that they can, in fact, often get even innocent people to confess. These are what we call false confessions, okay? So I want you to think about that, the power police have, where these interrogations occur, what's being said, and really think, could a person wrongfully confess? And the research has shown, yes, they definitely can. Now, the problem is when they confess, it's almost always used against them. It's almost never excluded. And it often leads to wrongful convictions, even when the person didn't do it. Okay. So they use what's called this Reed method. It's a very aggressive form of questioning that has contributed to a lot of wrongful convictions. So, because of this, some states are now requiring the interrogation process to actually be videotaped. So what would be the pros and cons of that? Why would you want interrogation videotaped? Or why would you not want the interrogation videotaped? More and more departments are leaning towards videotaping interrogation. So as soon as an interrogation begins, the videotape is recorded. And they not only record your answers, they record the questions, and the Mirandas and everything else need to be videotaped as part of the interrogation process. And that will all have to be turned over to the defense also. So that's it for interrogation. Here's a quick review, fill in the blank, see if you can fill it in. When you're ready, start the video again, and we'll see if you got your answers right. So hopefully you got all of that right. So we are now done with, oh, and don't forget, you still have chapter 6 discussion, is talking about the exclusionary rule, what you think about the ultimate consequences when police violate any of these procedural rights. So that's the end of chapter 6. That's a quick overview of procedural law. Like I said, we offer a class next semester, which is a complete look at each of these things in way more detail. So if you're interested in this and you find it fascinating, make sure that you register for criminal procedure law in the fall, in the spring. So that's all I have. We are now done with chapter 6. Woo-hoo. And I will be returning next week. So we're done with chapter 6. That means we're done with all policing. So we're done with chapters 4, 5, and 6. That means it's time for your next exam to open. So make sure you review chapters 4, 5, and 6. You know all the information. And then when you're ready, make sure you take exam number 2. Okay? Because next week we move into the court system, and we're going to spend a lot of time talking about the court system. So have a great weekend, and I will see you next week.